SJC-11490, U.S. Bank National Association v. Edna Schumacher et al.
Thank you.
All right, counsel, let's proceed.
Good morning, Your Honors. Max Weinstein for the appellant, John Schumacher, with me, Paul Collier. May it please the court. We're here today, Your Honors, because, and I here quote from the brief of Appellee U.S. Bank, quote, the Section 35A notice did not fully comply with the statute. That statute, Chapter 244, Section 35A, states that no foreclosure in Massachusetts may proceed until a mortgagee gives a homeowner a right to cure a default on their mortgage and provides specific information necessary to make that right meaningful.
Can I ask you, I mean, if we start, for the sake of argument, and say that this was a non-compliant notice, isn't there the pivotal question about whether or not that precedes the commencement of the foreclosure process? Ibanez seems to have said that the foreclosure process starts with the first publication of the notice of sale, which is 244, Section 14, and that the statute on which you rely, 35A, is prior even to the acceleration of the underlying debt. How is it that that is a part of the foreclosure process?
Your Honor, Section 35A articulates a requirement that must be met for any power of sale foreclosure to be valid. And indeed, the statutory power of sale itself provides that before foreclosing, a mortgagee, quote, must comply with all statutes relating to the foreclosure of mortgages by exercise of the power of sale. By its plain term, Section 35A is precisely such a statute, precisely a statute relating to the foreclosure of mortgages by exercise of a power of sale. And indeed, the legislature intended that it be understood as such when it enacted it in the chapter entitled Foreclosure and Redemption of Mortgages, and specifically made it applicable to any method authorized by Chapter 244, of course, including power of sale foreclosures conducted pursuant to Chapter 244, Section 14.
But the legislature, with respect to notice of sale, required you to record an affidavit saying you complied with the notice of sale. There's nothing here which requires any recording that you complied with 35A, which means there is no way that anyone who purchases a foreclosed property is going to know whether they have clear title.
Well, of course, in this instance, Justice Gantz, the purchaser at the foreclosure sale knew full well whether 35A had been complied with, because
But
the
if
purchase.
U.S. Bank had sold the property at foreclosure to a third party, 3-4 years from now, isn't that third-party buyer at risk that someone's going to come forward and say the foreclosure was void?
Well, I think it would have to be determined on a case-by-case basis. 35A itself requires the filing of 35A notices in several locations, including in any proceeding to foreclose the mortgage. The land court, by its own rules, requires the filing of a 35A notice in any proceeding pursuant to the Service Member Civil Relief Act. There are frequently ways in which any prospective purchaser of a foreclosed property will have notice, actual or constructive, of a 35A notice and whether or not it's compliant. But beyond that, this court has observed on numerous occasions and for some time that there will always be title defects that are not necessarily apparent from the state of the registry.
But this is, I mean, especially with the revised 35A, the concept of strict compliance, when you add this idea of good faith negotiation in the revised, means it's going to be very hard to show that there was strict compliance. And indeed, there's an amicus which said there is usually not strict compliance. Doesn't this essentially mean that virtually any foreclosed property is going to be at risk of being declared void because there is some failure of strict compliance with either this 35A or the revised 35A?
Your Honor, I would note that that is precisely the same argument that this court heard when considering the Ibanez matter, that virtually every foreclosed property in Massachusetts would be at risk of invalidity because the widespread practice at the time was not to obtain an assignment of mortgage before foreclosing. And indeed, homes continue to be bought and sold before and after foreclosure in Massachusetts.
But the difference is that a buyer who is purchasing a foreclosed property could check and see whether or not the mortgagee at the time of the notice of sale had recorded as the mortgagee, but you can't do that here.
I think there certainly are instances in which you can, in which it is a public record. It's also a matter of law, clear statutory text under 35A that these notices be kept by the Division of Banks. But also there's nothing preventing title insurers from requiring disclosure of 35A notices at the time a property is sold at foreclosure. And there is nothing precluding parties from searching land court records themselves to determine Section 35A.
This only goes, I mean, this statute wasn't enacted until 2007, so it's not going back to time immemorial.
That's correct, Justice Botsford. It was made effective only as of May 2008.
Hey, can we focus on the notice for a moment? It was directed to your client, was mailed to your client. Your client received it.
Yes, Your Honor.
His loan number is correctly noted on there, his
Yes, Your
mortgage number? Okay. The balances overdue are correctly noted on there?
To the best of my knowledge, Your Honor.
This is sent from a mortgage servicer, is that correct?
It's sent from America's Servicing Company, yes.
Okay. And it gives him a phone number where he can call and, in fact, make inquiry and provide any correction to the information, correct?
That's correct.
And it tells him he has 90 days on which to bring the deficit up to date, correct?
Yes, Your Honor.
And it provides a series of places where he can call to get financial assistance to help bring that up to date, okay? And so what's the problem here? Did he call? Did he make a call and was unable to sort of get through?
Your Honor, this goes to facts that are not strictly in the record before the court, but Mr. Schumacher absolutely did call America's Servicing Company, and like so many other Massachusetts homeowners, was unable to successfully negotiate the maze of mortgage servicing.
Okay, so he was able to contact the mortgage servicer.
Yeah, Your Honor, and I should be clear, I do not know whether that was in response to this particular notice or whether those conversations were already ongoing.
And he was unable, whoever he contacted, was unable essentially to negotiate a settlement of this outstanding balance.
Yes, Your Honor.
All right, so he was on notice, he knew the situation, he had people to call. Why isn't the essence of this provision complied with?
Because Section 35A does not authorize mortgagees to disclose some of the information set forth in the statute. It does not authorize mortgagees to disclose so much information as would be useful.
What wasn't disclosed? What wasn't disclosed?
Section 35A prohibits foreclosure unless the mortgagee is identified, the
And
name
you're-
and address of the mortgagee.
Okay, so the mortgagee is identified, of course, as U.S. Bank National Association trustee Bear Stearns with an address, okay? And they were the ones that foreclosed, right?
They were not the mortgagee at the time of the notice, however.
They were the ones that foreclosed.
That's correct, yes, Your Honor.
All right. So you're saying because there hadn't been paperwork making them the mortgagee, at the time this notice was sent, that's the defect.
At the time this notice was sent, U.S. Bank had no legal interest in Mr. Schumacher's mortgage. U.S. Bank received an assignment, received a transfer of an interest in real property on March 10th, 2009,
And
4
foreclosed.
months later.
And foreclosed.
And foreclosed.
And you said they had no interest at all, not even in, how did they get the mortgage?
They received it by assignment from MERS, the Mortgage Electronic Registration System.
They buy it, or was it assigned because it was part of a secured package that they had equitable interest in?
Your Honor, that's not something that was revealed by discovery in this matter. All that is in the record is that U.S. Bank first obtained an interest in this mortgage on March 10th, 2009.
The purpose of the statute is to give people notice and an opportunity to do something. Why doesn't this do that?
The statute and its purpose are apparent from its plain text. It prohibits foreclosure until the name and address of the mortgagee is disclosed to a homeowner. It's important information. It is the entity that has legal title to your home in a title theory state. And it is a judgment that the legislature made.
By the way, the address and the name of the foreclosing entity is here. Did he try to contact them,
That I'm unaware of, Your Honor.
U.S. Bank?
I mean, of course, the other problem here is that MERS was the mortgagee, and if you had called MERS, they would have said, we just happen to hold the mortgage. We don't have anything to do with the loan. You have to call the person who's the note holder. I mean, isn't the whole purpose of it to reach the note holder? Because only the note holder can modify the note?
Your Honor, the structure of securitized mortgages means that the precise right person may be neither the note holder nor the servicer. However, MERS, by the terms of the MERS system itself, is the owner of legal title to a homeowner's home. And that's important information, and it must be disclosed. Now, it's true that MERS identifies itself as an agent. And so the mortgage industry, by adopting the MERS system, has made the name of the owner of legal title to a homeowner's home an agent. But it strikes me that the appropriate response to that development is not to say, well, nobody needs to be disclosed. The statutory mandate of Section 35A no longer matters. It strikes me that the appropriate response to that is if the owner of legal title purports to be an agent, the principal ought to be disclosed as well.
Mr. Weinstein, if I want to get back to a point that you were alluding to when you talked about title insurance, and they can require proof. Whether it's title insurance or whether it's a prospective buyer from the mortgage, the person who takes title at the mortgage foreclosure sale. If there were an affidavit from the mortgagee indicating that something along these lines, on such and such a date, I sent a letter compliant with Chapter 244, Section 35A, a copy of which is attached here to the mortgagor, and da-da-da-da-da-da. And that were recorded in the Registry of Deeds. What effect would that recording have? Would it be prima facie evidence? Would it be conclusive evidence? What effect would it have? What solace could it give to a buyer?
Well, it's certainly within the legislature's ability to make precisely such an affidavit prima facie evidence that Section 35A had been complied with, in much the same way that foreclosure affidavits have been held and are, as a matter of statute, prima facie evidence of compliance with Chapter 244.14, rebuttable, of course, by evidence that there was, in fact, no such compliance.
Okay. And just as an additional question, why is this set of circumstances not the same as, at least practically speaking, not the same as a mortgagor who defaults on the payment, and that is a matter that has to be resolved in equity, as opposed to being void ab initio?
Your Honor, where there's not compliance with the legal requirements for obtaining title by power of sale, that foreclosure is void. Section 35A, by its plain terms, imposes a requirement that must be met for a power of sale foreclosure to be valid. In the event that requirement isn't met, the foreclosure sale is invalid. Here, U.S. Bank is seeking legal relief. It is seeking a possession of Mr. Schumacher's home. It either has that right to possession, a superior right to possession, or it does not. If it has not obtained title to Mr. Schumacher's home, it does not have a superior right to possession, and judgment should enter for Mr. Schumacher.
But the only reason it doesn't have right to possession, you say, is because this letter misstates the time when the bank actually had the power to sale.
It misstates the entity that had legal title to
Legal
his home,
title. And
as well as other information in that is required by the statute. It is.
What other information?
The statute specifically prescribes that the notice identify a loan originator, a loan broker, if there was one. The by far most significant violation of the statute is the failure to name and identify the mortgagee. But there are other ways in which it is non-compliant.
They identified the mortgagee, the
not-
wrong mortgagee at the
Yeah.
time, because they didn't
Erroneously
hold
did.
legal title. But they were the entity that foreclosed.
They were the entity that later foreclosed.
They had the mortgage when they foreclosed.
Just as the entity that foreclosed in Ibanez was later assigned the mortgage loan. The question is the present authority of that entity to be named as a mortgagee, identified a mortgagee, and it, quite simply, U.S. Bank undisputedly was not that entity.
How were you prejudiced?
Mr. Schumacher faces eviction by an entity that is claiming superior right to possession of his home, an entity that has...
How were you prejudiced by this notice?
Mr. Schumacher faces eviction from his home by a party that has no superior right, that has recorded a foreclosure deed against his home, despite not having valid title to such foreclosure deed. That's grave prejudice.
Chief, if I could ask one more question. This I know is the 2008 statute, but under the 2010 statute, it requires also a good faith effort to negotiate and agree upon a commercially reasonable alternative. Is it your view that the failure of strict compliance for that would also void the foreclosure?
Your Honor, the new statute sets out, and I think perhaps Section 35B is even the most instructive in this regard now, sets out a very precise process by which the negotiation to which the court refers is supposed to occur. To the extent that there is any concern that strict compliance with an unspecified standard of commercial good, reasonable conduct is at issue, I don't think that's the case. I think that the new statute provides pretty explicit guidance as to how those negotiations are to take place.
Okay, but is it your view that if there were to be a finding that there was not compliance with the good faith effort to negotiate and agree upon a commercially reasonable alternative, that too would void the foreclosure?
Yes, Your Honor, it's an absolute mandate from the legislature that those negotiations occur.
Thank you, counsel.
Thank you, Your Honors.
May it please the court, Jeff Patterson on behalf of U.S. Bank. I'd like to start, Justice Gantz, with the point that you brought up at conclusion, which is the concern of my client and banks in general with the proposal put forth by the appellants that strict compliance goes beyond just the statutory power of sale and can apply to other statutes that relate to foreclosures or relate to mortgages. There then is no dividing line. So that would not only mean you would have to have strict compliance with 35A or have a void foreclosure, you would also have to have strict compliance with 35B or have a void foreclosure. And you start bringing in concepts where strict compliance, when you're talking about a good faith duty to modify or a good faith duty to consider a commercially reasonable alternative, would create enormous challenges.
But how hard is it to strictly comply with the statute? I mean, the letter is pretty straightforward.
Well, that's a great question. The issue that we have and the reason this is difficult specifically is the term mortgagee, and to be clear, the statute doesn't just say you have to name the mortgagee. It says the mortgagee or anyone holding thereunder. So it's not just limited to the mortgagee, but focusing just on the term mortgagee for a second. I think there are at least two and maybe three entities which could qualify under the definition of mortgagee. Certainly MERS, who had been assigned the mortgage, could be considered a mortgagee. But also, if you read this court's opinion in Eaton, it talks about in Section 17 of the statute where the legislature, when they use the term generically mortgagee, they actually mean mortgagee and note holder. In this case, it was stipulated below that U.S. Bank was the note holder. So if you adopt the...
But you start with, I mean, Ibanez makes very clear, you start with the mortgagee.
Absolutely, that the definition in Ibanez of mortgagee is just anybody who was the original mortgagee or was assigned the mortgagee. But the court did recognize in Eaton, and one of the reasons why the decision was made prospective in Eaton was a recognition that the legislature, when they used the term mortgagee, sometimes they meant what Ibanez considered as mortgagee, the person who had been assigned the mortgage, but that they also considered the note holder who had the ultimate authority to direct the foreclosure would also be swept under the definition of mortgagee. So in this case, you've got a question about MERS could qualify as a mortgagee, U.S. Bank could qualify as the note holder, which also would be under the mortgagee.
No, no, the note holder by itself is never the mortgagee. You need the mortgage.
And under the statute does recognize that it's mortgagee or anyone holding thereunder. The use of the term holding, when you talk about a note, you're talking about holding a note. When you're talking about mortgage, you're talking about an assignment of mortgage. So the statute itself doesn't say you have to name the mortgagee, period. It says you name the mortgagee or anyone holding thereunder.
Yeah, but Eaton, I mean, there's some old case law from the 1800s that sort of plays around that idea that you're just describing. But wasn't that put to bed? Wasn't it settled with Eaton that the statute means the holder of the mortgage? It doesn't mean the holder of the note.
By itself.
35A was not an issue in Eaton. So the statute here that we're talking about, 244, Section 35A, which says you name the mortgagee or anyone holding thereunder, this court has not interpreted what that language or anyone holding thereunder means. And our position is that language has to have some meaning. In other words, you wouldn't say you can name the mortgagee or the mortgagee. You name the mortgagee or anyone holding thereunder.
You're not going to say that the servicer holds thereunder.
No, but U.S. Bank as the note holder, and to be clear, although my brother said there was nothing in the record to indicate U.S. Bank's interest, it's actually a stipulated fact at appendix page 10 that U.S. Bank was the note holder at the time the notice was sent out.
So your argument is by virtue of U.S. Bank having been mentioned and having been stipulated to be the note holder, it falls under the term mortgagee or anyone holding thereunder, and therefore that the notice was compliant?
The notice was compliant as to naming the mortgagee. I do have to admit that there's a sentence that says the loan originator is N.A., not applicable. So we did not have perfect compliance or technical compliance based on the originator. But yes, at our position.
And the originator would have been?
Union Federal Bank of Indianapolis, I
Okay.
believe.
So it was applicable, it just wasn't named.
Yes, that's correct, Your Honor. It was not named. And the two questions that we're dealing with here, I think, are two sliding scales. You've got a compliance sliding scale, whether it's technical compliance, substantial compliance, and you've got a remedy sliding scale. The appellant is asking this court to go to the extremes on both of the scales, to require strict compliance in every aspect of the notice, and to require that the foreclosure be void at law, not voidable. That's a key distinction here.
Well, isn't that what Ibanez says?
Well, what Ibanez says is for the statutory power of sale, which is chapter
18321.
and 11 through 17C of 244.
Yeah, but let's start with 18321, which says you have to comply with the statutes that govern mortgages, mortgage foreclosures under the power of sale.
It does, and then the Ibanez court, the Ibanez opinion goes on to say those statutes are 244, sections 11 through 17C. It doesn't say and 35A. And by extension or by analogy, I would refer to this court's decision in the Mott case, which dealt with the Service Member Civil Relief Act, where this court recognized, even though there's a requirement to file an SCRA action before the foreclosure, that the failure to do that doesn't render the foreclosure void. It renders it voidable because someone can challenge it if they were actually in the military and there was not an SCRA action filed.
Well, that's because you don't have to do it at all. You do it only to protect yourself.
Well, but there is a requirement. If you read the language of the statute, it says you must file before you seek a default or anything else against someone in the military. This court has interpreted that even if you don't do it, the foreclosure can still be can still be valid unless the person was in the military. Similarly, in this instance, the position that we're submitting is not that this would, a failure to comply with 35A would never have any impact on the foreclosure. What we are submitting is, because it's not part of the specific power of sale, the language of Ibanez that required strict compliance and that found the foreclosures in Ibanez void ab initio, or void as a matter of law regardless of whether they were challenged, that in this instance the appropriate standard should be substantial compliance and voidable. In other words, a court looking at the facts of a case, and I go back to what Justice Cordy asked, was there any prejudice in this case? In this case, there was no evidence below that there was any confusion or any failure or any inability to cure the default. In an appropriate case where someone, for instance, if the wrong mortgagee was named, someone sent the money to the wrong company, it didn't get to the right company, they actually made an effort to cure. and could not cure as a result of a defect in the notice, that might be a situation where the foreclosure would be voidable. But that's based on the facts of the case. The issue here is whether or not the foreclosure should be void as a matter of law, meaning the courts have no discretion whatsoever, it's automatically void. We would submit that the Ibanez decision, and frankly going all the way back to the Moore decision, which is in the late 1800s, recognizes if you violate 11 through 17C or the terms of the mortgage, the foreclosure is void as a matter of law, no discretion. It's as if it didn't happen. There are other defenses recognized in Moore and Wayne and Wing which make the foreclosure voidable. That means there are other things that lenders have to do. If they don't comply with all that, depending on the facts of the case, it could be voidable. That's the situation which we believe we're in here, much like in the Service Member Civil Relief Act. In the appropriate case, the foreclosure may be voided as a result of a failure to comply with that.
But isn't that because of an external federal preemption issue? There's a federal law protecting soldiers and sailors?
Well, there is a federal law, but there's also a state version of the same law.
But here, you've got the legislature acting in 2007, effective in 2008. I haven't looked at the legislative history yet, but I would think it's pretty clear that they were seeking to protect homeowners here. So I don't.
Absolutely, and the purposes of the statute were served 100% by the notice that was sent in this case. Wow. The purposes of the statute were to allow someone, first of all, 90 days to cure the default. So they needed to know how much was the default, and they needed to know who to make payment to. Both of those are clearly identified in the notice at issue here. The third thing they wanted to do is if there was a dispute about the default, you needed to provide information on who to contact if you say, I'm not in default or I don't agree with the default. That was provided in this notice. The fourth thing they wanted to do is make sure they had information regarding the agencies in the Commonwealth that help homeowners facing foreclosure. Those numbers were included in this
How hard was
notice.
it for you to get it right?
Well, if you're talking about the mortgagee, and if you look at the decisions of the lower courts, I would submit this is not a simple issue. There are decisions from the land court, the housing court, the federal court, and the superior court all over the board on what is the appropriate definition of mortgagee or anyone holding there under 35A. And I would not in any way submit that the judges who've decided against our position have no basis or the judges that have decided for us are 100% right. I would submit this is a very difficult issue that we're struggling with on what the statutory terms mean in light of Ibanez.
You're suggesting that the bank would think, gee, we just don't know who it means when it uses the word mortgagee, or is that what you're saying?
Well, I'm saying there are multiple interpretations that you could take of the phrase mortgagee or anyone holding thereunder. So to say, how hard is it to get it right? I would submit that the U.S. Bank listed as the note holder in this case, that is right. That falls under the phrase or anyone holding thereunder.
And I take it the note holder had an equitable right to the mortgage and indeed got the mortgage and then foreclosed.
Correct. And one other layer, again.
And who could modify the terms of payment here? The mortgagee or the note holder?
The note holder. The note holder would have authority. So if you were seeking a modification, you deal with the note holder and its servicer, in this case, America Servicing Company, both of whom were identified. The other thing, Justice Botsford, getting back to your point on why couldn't you just get it right, is you have to also overlay the division of banks. And I want to be clear that the regulations were not in place at the time this letter was sent, so I don't want to suggest that we were relying on the regulations. But the division of banks was charged with providing regulations to interpret or to clarify what the statute meant. In the frequently asked questions, and this is raised in REBA's, the Real Estate Bar Association's amicus brief, in the frequently asked questions, the division of banks itself says it's fine not to name the actual mortgagee. You can actually name the servicer. You can replace the servicer's name with the mortgagee's name. So that's the division of banks itself in their guidance, and in the regulations they include mortgage servicer in the definition of mortgagee. So the division of banks itself has said it's okay to name either the mortgagee or the mortgage servicer. So there's not just one right answer when you talk about doing the notice, especially with regard to the mortgagee or anyone holding thereunder, and that's why the concept of strict compliance becomes very, very difficult on a current basis and on a going forward basis because, again, if you look at the decisions, many judges who have spent a lot of hours looking at this in the Boston Housing Court, Judge Winnick, or Judge Coven down in Quincy District Court have come to very different opinions on how this should be interpreted and what should be the remedy. And I assume that's why this court took the issue up, is there are very divergent opinions. And again, we would submit that the history of cases here in the Commonwealth say strict compliance and the remedy of void is available only when you don't comply with the terms of the mortgage, which is not claimed here, or 11 through 17C.
Well, any question here that if Schumacher had come before the foreclosure and said, this is a defective 35A notice and does not identify the mortgagee, that he'd be entitled to an injunction to postpone the foreclosure until you did it correctly?
I think in this situation, because I think we properly named the mortgagee or anyone holding thereunder, I don't think he would have been entitled to an injunction. But let's say a situation where you named somebody that had no relationship whatsoever to the loan, it was just a complete computer error mistake, then yes, there would be an ability to get some kind of relief pre-foreclosure. Although likely what would happen, Your Honor, if this issue was raised, is the bank would send out another 35A notice and start the 90-day or 150-day period over again just to correct the defect,
Right,
to
well,
avoid.
the injunction, I assume, would say you cannot foreclose unless you do a proper notice.
Yes, sir, yes.
And then wait the 150 days now in order for that to take its time.
That's correct. And I do want to be clear that I'm not saying failure to comply with 35A, that there should be no remedy for that and that there should be no impact. What we're saying, though, is it shouldn't be the most draconian remedy of void at-law foreclosure. Certainly, there are numerous ways that courts deal with these issues. Pre-foreclosure injunction, a 93A claim if there's actually been damages and unfair conduct. The Division of Banks has enforcement authority. So there is a broad spectrum here. The appellants in some of the amicus brief tend to suggest that if you don't say the foreclosure is void at law, then you're completely ignoring 35A. I don't believe that's accurate. I believe there's a spectrum of appropriate remedies, both equitable and legal, that this court must decide what is the appropriate remedy for violation in this case, which in my view boils down to not naming the originator, putting NA, even though the purposes of the statute were completely served, and given the practical implications and the practical problems that would result from a finding that all these foreclosures are void when there's no ability to check this on the record, that the remedy should be voidable and that the compliance standard should be substantial compliance, not strict compliance. Unless there are any further questions, I'll rest on our briefs. Thank you.
Thank you.